Good morning, everybody. It's a pleasure to be here and to be invited by California Southern to uh, discuss alternative dispute resolution from a legal point of view. Uh, I was at the courthouse yesterday and I was thinking about some things about alternative dispute resolution, and I don't know, but I guess as I get older, I think about things, and when I tell people what I'm thinking about, sometimes they wonder. And I was looking at the statue of Lady Justice, and I noticed that Lady Justice had a bandana around her eyes. And I was wondering whether she didn't want to see what was going on in the building, or whether she didn't want to see the same people come day after day after day. And I thought about that, and I asked myself the question, now I know why many of my clients come to me and say, I don't want to spend any more money to be right. And so I think this is a very pertinent topic and something that we really need to speak to as alternatives to traditional litigation. I also was thinking yesterday of an event that I witnessed in Texas back in 1991. I have an airline background. I went to work directly out of college with TWA in New York City. And TWA is now a defunct airline, as many of them are. Excuse me. And TWA was influential because it was founded by Howard Hughes out here on the West Coast, and then it did primarily its business and headquartered out back east. And I was thinking of the event that I witnessed in 1991 between Herb Kelleher, who was the president and CEO of Southwest Airlines, and a gentleman by the name of Kurt Herwald, who was the president of a very small aviation company called Stevens Aviation. And what made that event unique was that Stevens Aviation was using a slogan in their advertising called Plain Smart, Plane Smart. And Herb, in his own way, being from Texas, who was a cigarette-smoking, Jack Daniels kind of guy, decided to put in his advertising just plain smart, just Plane smart. So, of course, it came to Mr. Herwald's attention, and the talk of litigation was in the air. Trademark litigation, trademark infringement. So Herb, in his own way, being a kind of a maverick in his own way, challenged the 38-year-old Mr. Herwald, Herb being 61, to an arm wrestling contest, and whoever won, they would get the advertising. So what happened was they touted it for charity, people paid money. Herb Kelleher, who was the president and CEO of Southwest, prepared for this by drinking more Jack Daniels and smoking more cigarettes, and arrived in a limousine and carried on like a rock star. It ended up that, as predicted, Mr. Herwald won, but was so impressed with Herb's demeanor and the way he approached this that he gave up and said, for a few dollars, we'll give it up to you. So I was thinking, if that isn't the most unique alternative dispute resolution, I haven't seen it. So today, I want to try to stay away from the physical actions that can be associated with ADR. Although if you're a family lawyer, you'll sit in family resolution and be the only one in the room who isn't yelling, but you're getting paid. So it's kind of okay. So I want to speak to other views, other opportunities, and other options. So the first thing that we always want to talk about from a sociological point of view is what is conflict. And there's lots of theories as to what conflict is and whether it's healthy or not. And to many, conflict is normal, it's even healthy, and in fact, many relationships are made stronger by virtue of this kind of conflict. Because we all know that since we all come from different parents, we were schooled by different backgrounds, we have different traditions, we have different customs, we're all not the same. And that's good. And since relationships often lead to conflicts, as anybody who's married would know that, we need to learn to deal with them in a healthy way. And it's crucial, whether you're talking about a working environment or a professional environment or even a personal involvement. However, if conflict is mismanaged, what will happen is the relationship can never be sustained. So what we want to do is promote conflict in a manageable way, to handle it in a resourceful, respectful, and positive way, and the ultimate goal being to strengthen the relationship. And one of the biggest advantages of ADR is that we want to sustain the relationship. It's not something that we want to sacrifice by virtue of getting a solution. So by learning the skills that we need to handle conflict, we can use those same skills to handle court cases in other ways other than the traditional litigation. If you look at the basis for conflict, it's because the needs of people just aren't satisfied. And it's the needs rather than the wants that we want to focus on. People can disagree about values and morals and ethics and perceptions and ideas and desires, but these all appear trivial when you look at what the specific needs of people are. And when they're deep and personal and relational in nature, it's very difficult to get people to come and speak civilly, let alone to try to cooperate towards a mutually achievable solution. So that's our goal from the legal point of view, is to try to introduce this process either mandatorily or elective and try to resolve some of these disputes so that you don't have to spend a lifetime trying to get your case heard from the time you file it till the time you actually hear it. So let's look at some numbers. I heard a lawyer the other day tell me that the way this looks, my grandchildren will be settling this. In the mid-90s, California, being the visionary state that it portends to be, said that our goal under the Trial Court Delay Reduction Act, that we wanted to get all cases disposed of in 2 years. Now, disposed is a key word, whether it's resolved or whether it's dropped or whether it's settled. It's a war of attrition at times where people just give up, as I said earlier, because they don't want to spend any more money to be right. What's interesting is that if you look at the statistics in California, the average length of time from start to finish is 22 months. Now, what helps that out is that only 3.5% are resolved by actual trial. So that means that we're doing something in that waiting period to resolve these ahead of time. So let's look at Orange County. In the fiscal year 2012 and 13, there were 920,000 cases filed in the entire state of California. Of these, 71,000 of those cases, or 8%, were filed in Orange County. So that just gives you some baseline. Now, of those cases that I just enumerated, 84% were resolved prior to trial statewide, and a corresponding number, 83%, in Orange County, which means that 4 out of every 5 cases that are filed end up being resolved in some way, shape, or form prior to trial. And for the past 8 years, civil cases have been referred to ADR, and these are the things that people have elected. Overall, 43% selected mediation. I think that's because, as I'll point out later, that still leaves the decision in the hands of the parties themselves. 22% elected arbitration. 28% took settlement offers prior to trial, and 7% elected something that's still in its evolution, which is neutral evaluation. So about 40% of the cases were settled without ADR. Some were private, some were through settlement conferences, and some were mandated by the court. In every family law case, they do order court-ordered mediation. Whether it's successful or not is left to the participants. And when I do mediations for the family court, and I mostly represent the children, which is the byproduct of this relationship, I tell the parents right away to take off the labels off their foreheads that say husband and wife. That didn't work. And they need to put father and mother, and let's get busy thinking about this blessing that we're going to have with us till they're 18. So we want to foster that belief. So one of the things that I learned in law school was if you have good facts, argue the facts. If you have good law, argue the law. If you don't, argue the Constitution, or get some reputable people to support whatever contentions you're going to make. So throughout my presentation, I'm going to try to throw people in that are genuinely reputable to try to support what I'm trying to present. John Kennedy said that our task is not to fix blame on the past, but to fix the course for the future. So, and Sandra Day O'Connor, former Supreme Court Justice, and I believe the first woman ever appointed to the Supreme Court, said that the courts of this country should not be the places where resolution of disputes begins. They should be places where disputes end after alternative methods of resolving disputes have been considered and tried. The see you in court approach that's been used throughout time, and mostly in my experience now by young lawyers that just graduated from law school. The first words out of their mouths are, "I'll see you in court." I say, "Good, we'll visit and we'll have a nice talk." So don't get excited. The seeing you in court approach doesn't work. It's the worst way to resolve legal disputes, but unfortunately, in some cases, it's the only way that we can get people who are caught in concrete to listen. As everyone knows, when you go to court, there's only two winners: the lawyers. Good for me, bad for all of you. Court litigation is costly, it's invasive, it's time-consuming, and for the most part, it's adversarial. And often ADR decisions can be sealed, especially if they involve children, and it's not as publicly known if you don't want to have that information out there. So what I'm going to try to do is to give you an overview of what ADR is, define what it is, how it's used, and why I believe, and the numbers support, that this may very well be a better alternative to the actual court litigation. And then we'll talk about something called the ADR continuum, where there's a series of alternative ADRs that you can pick that stem from more personal involvement all the way up to less personal involvement, where we let others come in as objective third parties to make those decisions for us. The agony speech. Every one of my cases, I tell the client the very first day, there's going to come a time when you're going to say to me, "I don't want to pay any more to be right." Over 22 months, lots of things change. Relationships get worse. Evidence and testimony gets distorted. Children get older. There's more visitation. There's all kinds of things that go on. So we have to investigate some other alternative. So what is ADR? Well, ADR was a term that was coined to describe a series of approaches by which we could resolve conflict not through the traditional ways using the court system. It can be formal. It can be informal. It may involve the cooperation of parties themselves, or we may invite neutral third parties to come in and either facilitate the process or reach an ultimate decision. It's been favored in California, and California seems to lead the nation in just about everything, with a few exceptions, but it's been favored in California since 1999. So what are the kinds of things that you can use ADR for? Well, really, it's the whole gamut of disputes that occur between people living in society. It can be disputes in business, it can be disputes of land use, it could be disputes of property, certainly family disputes, certainly consumer or collection disputes are applicable here, and things that relate to the other items on the list: employment, landlord-tenant, personal injury. What does ADR get you that traditional litigation doesn't get you, other than less ulcers, less gray hair, and more time to do the things that you really want to do? It'll offer you an earlier resolution of the conflict. It's more timely and less delay. It's also less costly. It's more predictable in terms of a decision because you have a hand in guiding it than traditional litigation, where you're depending on either a judge or 12 people who drive cars and vote in the state of California and may not want to be in jury duty. Flexibility is attractive when you use ADR. It allows for more control. As I said earlier, it's less invasive. It fosters more communication. And most importantly, in ADR, you can sustain the relationship. If that relationship is important to you, this is something that can be fostered greatly by the use of ADR. And at times, it will be more satisfying an outcome than going to court. And finally, from the system point of view, it relieves the court congestion, which is overwhelming to say the least. But there are downsides to ADR. It may not be suitable for every kind of dispute. If the ADR is binding, you have to agree up front to be bound by the decision and waive appeal. There are certain things that you get in court with traditional due process and other formality that you don't get in the ADR process. If timing's critical, sometimes ADR advances much too fast before people have really thought out their position, so sometimes people make decisions and then have buyer's remorse the next day. And there's always, as any court proceeding or any court process, there's always a statute of limitations or a limitation in terms of time. So this diagram that I put up lists the alternatives that exist within the ADR continuum from a legal point of view. You can start over here on the left-hand side with negotiation, move through mediation to arbitration and to litigation. And if you look at this, there's more personal involvement to the left side, less personal involvement to the right side. And you see the costs go up on the continuum as well. It starts out low and works its way up to a higher level. Also, you relinquish a lot of the control at this point, and you allow other parties and other organizations to decide the outcome. As you move from left to right, you also saw that the amount of time and resources become incremental. The ADR processes evolve from you having total control over the decision to moving to the far right, where we go into the traditional ways of handling things. So there are two types of ADR, informal and formal. Informal involves basically the parties trying their best to resolve this themselves. Now, I've had people tell me, well, why do you have to put a label on something they should have been doing all along, and they got to this dispute, so what makes you think that it's ever going to turn around? Well, as I mentioned earlier, there's a cost factor, there's a time factor, there's an invasiveness factor, where people, when they're faced with the possibility of litigation, maybe change their hat a little bit, and therefore they're able to look at the amount of effort and time and motivation, and they might realize that maybe this relationship, which I really don't like so much now, may be worth preserving. So the first thing that we always recommend is negotiation. And negotiation is a voluntary process by which the parties attempt to resolve their dispute in some mutually satisfactory way through either formal or informal discussions. And they focus on the problem rather than, in principle, determining who was right and who was wrong. The advantages of negotiation are that you remain in complete control of your outcome. No result is imposed upon you because you are going to make that decision yourself. And you're free to walk away or just discontinue the process at any time. In principle, it's least confrontational. I would say that in a formal sense. And it helps preserve this relationship, which is something that is admirable. The danger, however, with negotiation to date has been that we as a society are trained from the very beginning when we are children to survive and not to be accommodating and not to be compromising and to win at all costs. I mean, Darwin's whole book is predicated on the survival of the fittest. And when people get their backs to a wall, they want to win. Whether you negotiate for a house, for a car, you beat up the other party so much that every dollar you save is good. The other person, who cares? We're not going to sustain the relationship. We're not going to ever see those people again. So we need, as a society, to change our outlook from win-lose to win-win. We need to do several things to accomplish that. And some of these are listed here. We need to separate the person from the problem. How many people do you know can't do it objectively? It always degenerates into a personality or some kind of character issue. That's why you see people in businesses crying after a discussion with some of their workmates, because it becomes personal rather than objectively about the problem. We should look for mutual interest. We should look to provide this win-win. We should focus on objective criteria. Now, objective criteria is when we use facts and rationality. And I'm reminded years ago, there used to be a show called Dragnet, and there used to be Sergeant Joe Friday. And this first line, every time he was asked and introduced, he would say what? Just the facts, ma'am. Or sir, that's what he would say. Because we can't deal with emotions. How many of you are able to deal with anybody at an emotional level way up here? Anyone who's married better say, I can't. that you're being dishonest. Can you communicate with anybody up here? No, you can't. So we need to find a better way. We need to look forward, not backwards. I was an accounting major when I first started college, 6 months. And after I looked back in time, enough time, that I was equating myself to a rearview mirror, I said, there's got to be more to life than this. And I don't like numbers, so I probably should become a lawyer or something and deal with good numbers as opposed with all of those numbers. And this is important, that you look forward, not backwards. I can't tell you how many clients and how many mediations I've done where it's a history lesson. She did this and he did this, and this poor little child is stuck in the middle of this and didn't ask for these two. Because my dad taught me when I was much younger that there are 3 groups in life that you can't request: your parents, your in-laws, and your neighbors. You're stuck with these people for 18 years. We need to find ways to expand the pie through creativity. We want to sustain our relationship, as I've mentioned several times, and the goal is agreement. Now, on the other side, these are the people that don't do so good at this, and these are the people that are the followers of the Darwinism days, where it's a win-lose. You view the other party as an adversary. How many times have you heard the pronouns us and them? Stay away from them. When you point a finger at somebody to stay away from them, you better realize that there's 3 fingers coming back at you. And I can't tell you how many cases I've had where parents or guardians have messed up relationships for children, whether it's personal or little league or any kind of competitive sport, because they don't let children be children. And when a mother tells me that she does not want her child to play with that one, I, after checking the ethnicity chart, couldn't find a that one. So I don't know what that one is. But these children don't recognize the same things that their parents do. If you're a bad negotiator, you'll never state the bottom line. You will confuse needs with wants. And you insist on a position, and you get locked in concrete, and you can't move. And when we pin you down, you dance around it. And to you, relationship is secondary. You'll never see this person again, don't care, don't want to. Except they forget, as parents sometimes, that they've got this child, this blessing, for 18 years. And they're an input machine. They take in all the things that are going around. When you're not so nice to mom or dad, they remember that. So when the decision becomes when they're 18 whether they want to go with you or not, it's not such a straightforward decision. And probably the most important thing about this kind of negotiation, which is formally known as distributive or non-constructive, win-lose is the traditional vernacular, its goal is victory at all costs. Now, in doing this kind of negotiation, we've got to understand the difference between listening and hearing. Listening is not the same as waiting for your chance to talk. It also is not hearing. How many times have people said to you, I hear you? They are not hearing you. They are not listening to you. Hearing is the biological function by which sound waves go in your ear, rattle around, and listening is when the elevator goes up to your brain. When children say to you, I hear you, Mom, they're not listening. When your boss says, I hear you, they're not listening. Listening means that they pay attention. How many of you have been subjected to people, I didn't know you needed it on Tuesday. I didn't know you were off yesterday. Hon, I didn't know it was our anniversary yesterday. So we got to remember that hearing is not listening. And Ben Franklin said, remember not only to say the right thing in the right place, but it's more difficult still to leave unsaid the wrong thing at the tempting moment. Now, that's something everybody needs to think about, especially lawyers who tend to speak and then think about things. So, then if that's negotiation and it doesn't work, then we would escalate it to the next step on the continuum, which is mediation. Now, mediation by principle is that we bring a third party outside objective neutral party. It's hard to find somebody with all of those adjectives. to be chosen by the parties themselves to come in and facilitate. And they really become like a shuttle ambassador. They go from one and say, what do you think? And then they walk over to the other one and say, what do you think? And they're kind of like the Henry Kissingers of mediation. And basically, they just try to evoke, what do you think about this? And maybe promote a line of thought that hasn't been thought of before. Maybe start to understand that there are two parties to this, and maybe the relationship is important, or that we transfer what we want to what's in the best interest of maybe the parties and maybe people who get a benefit or get some kind of consequence as a result of it being resolved or not. The downside is that there's no authority for either party to accept it. And as one of my favorite actors in one of my favorite movies said, you never really understand a person until you consider things from their point of view. And that goes back to my theme of we need to understand the person, where they're coming from, try to sustain the relationship. Now, mediation has its positives and negatives, of course. Mediation tends to be the quickest, other than negotiation, and the most flexible approach. It tends to be less costly. The parties own the solutions because they end up, although being advised, they will participate in the decision. The relationship can still be sustainable. Unless you're in family court, then who knows what comes out of that room. It's good if feelings have gotten into the way, or in the way, and you promote better communication. And in the trial court, it's much better because if you can get them to agree in one stage or one forum, maybe they'll agree in the more informal forums. The cons, or the disadvantages, they may not abide by the solution, but that's true just about in anything. Or they may perpetuate and be resentful and enhance the dispute down the road. And since no decision is mandated, it doesn't have the force of law behind it, although the court does bless these things. So what we have to look at is some other possibility. And the difference in negotiation, as well as mediation, is we have to make that distinction between interest-based and right-based. And the difference is that interest-based helps the parties come up with a solution that they may not have come up on their own and maybe realize from a different platform as to how to solve the problem because they now focus on interests, what people need rather than what people want. If you're in any kind of confrontation or any kind of dispute, the first words out of people's mouth is, I want this. It doesn't say, I could settle for that or I could go get by with what I need. So we have to identify the issue and categorize it as a need rather than a want. So we go to this new education process where we encourage win-win as opposed to win-lose, and interest rather than rights-based. So when I teach negotiation, I ask, the first example we always bring up before the first day of class is a mother has two children. The two sisters are sitting in the room at the kitchen table doing what they do best, which is arguing. And the mother has one orange. And both of them say, oh, we want that, we want that. And what does she do? She cuts it in half. It's the old Solomon decision. She cuts it in half. Which is not a win-win or a win-lose. It's a lose-lose. Because neither of them got what they wanted. They wanted the whole thing. Now, this is interest. So the question is this an interest-based negotiation? Is it based on need or is it based on want? The answer is no. It is right-based rather than interest-based because people get part of what they want, but they don't get the whole thing. Now, what about if the mother had said to the two children, sweetheart, why do you want this orange? And she might say, because I want to have orange juice. And she might go to the other daughter and say, sweetheart, what do you want it for? And she might say, I want to use the rind for my cookies. Could we not then address needs rather than wants and get a win-win? Possibly. Another example might be if you're going to Best Buy or some other big box store to buy a big screen, similar to this one. And you traditionally want to beat up the guy or gal who's selling it to you to get the best price you want. And not leave them any profit. Or if you're buying a car, the same outlook. What if the salesperson were to say to you, hey, you know what, I won't give you as big a discount as you want on this, but we've got Blu-ray players, and some of them are being discontinued, and I cut you a deal on that. Maybe you can end up with both for the lesser price. So now you help inventory, you help the sales clerk, and you may have a relationship down the road where you may do further business. A client of mine went to Turkey. And of course, when you go on vacation and you're abroad, you think you're never going back. So he tried to beat up this merchant who was selling Turkish rugs. Oh, I can't ship it back. It's too big. I don't want to pay for this. And the fellow said, where do you live? And he says, Minnesota. I said, okay. He says, what if we cut a deal? I'm not going to lose every bit of money that I have into this, but I will give you a discount. But how would you like to rep me in Minnesota? And then you could sell that, and we'll give you a cut of each sale that you make. That's a win-win. So we need to strategically change the way people think. It doesn't have to be win-win at all costs. I'm sorry, it doesn't have to be win-lose at all costs. It doesn't have to be win-lose. It doesn't have to be lose-lose. It should be win-win at all costs. And we should change our headset. But that's difficult. So, looking at that kind of approach, if mediation's settled, great. You have a settlement agreement, everybody agrees on it, they each put in their own input as to the language. The one thing that we always want to caution is boilerplate. Because when there's a dispute, there's always some issue of who prepared it, who okayed it. And I know, as you do, lots of people who are so thrilled to carry out the transaction that's often supported by boilerplate, whether you're buying a car or a house or whatnot, that you would love to sign your name and initial all the way down and you don't read anything. The traditional example is a new employee who's so excited just to have a job. Gets every piece of paper they put in front of that person. They'll sign it. They won't even think about it. They give them an employment handbook. Oh, this is nice. This would look good on my bookcase, or maybe as a doorstop. Who knows? But they're just going to sign for it. And legally, they don't understand that they're really committing to each and every provision and term and condition in that book. So later they can't say, well, I didn't know that. I didn't know that was in there. But you got to read. You know, there's the old saying in law that ignorance of the law is no excuse. So no court in law is going to support that. So we need to caution them against that. And so if mediation works, wonderful. But what happens if it doesn't? Then we've got to go more to the right of the continuum. We've got to talk about arbitration. Arbitration is the highest level of ADR. We invite a third party in to possibly make the decision for the parties. Now we have to make a distinction, though, between binding and non-binding, because it has consequences if you elect one or the other, and it has consequences on, as a lawyer, what you present or what you don't present, and it has consequences as to recourse in court. And it also heads off a lot of knee-jerk reactions when you don't get what you want, and you say, I could do better in court. So binding means that the parties agree up front to be bound by the decision and waive appeal. Non-binding says they'll listen to it, see what they like, and then proceed with the process if they want. So that has to be pointed out, that arbitration has some pitfalls. I remember years ago I had a case where a young man came to me and said, my wife just took me off her dental program, and now I have crowns that I need. I said, do you know why she took you off? And he said, no. I said, you're divorced. You're not married anymore. I don't care. Before this divorce is finalized, before the settlement gets finalized, before we get actually divorced, I'm still bringing it up. I said, I'm going to tell you what's going to happen. We're going to put you on. You're going to testify. The other lawyer, if they got half a brain, is going to get up and say, I want time and cost for wasting my time. And if you want to twist her one more time, I'm telling you, the judge is not going to be happy. I don't care. Well, of course, they always say I don't care at the beginning, and then they do care after. So sure enough, we did all that. And the lawyer, as he should have, got up and said, I want time and cost. This is crazy. I want $500, and you're wasting my time. So the judge, who unfortunately was one that I had known while I worked for the courts in Orange County, who also swore me in the day I became a lawyer, looks at me and says, "You got anything to say?" So that's like a final exam setup question. And I thought about it, and I remembered what I had learned from him. I said, "Well, Your Honor, you taught me if I have good facts to argue the facts, if I have good law, argue the law. But I'm going to argue the Constitution, because nobody can find fault with that. He has a right to see his accuser. That's the only way they're going to communicate. So instead of charging me $500 for him, I'll recommend $300. Now, my client's absolutely corkscrewed in the chair by now. And he says, "How could you sell me out like that?" I said, "Believe me, you got off a lot easier." So just like a premonition for arbitration, if it's going to be good or bad, I remember the judge pulling me aside after it was over out in the hall, and he said, "You got to pick your clients better than that." And I remembered that. So now I have to exactly do that. So there's two kinds of arbitration. Either it can be judicially referred, or you can do it as private parties, and you have to make that election of binding and non-binding. As a practitioner, I've never done a non-binding arbitration and probably never will, because I don't want to show my hand and put on my case and then do it again. I will do binding if I need to. So why is arbitration better than mediation? Well, it's good for lots of things that mediation doesn't accomplish. And it goes back to looking at an objective finding which might promote the relationship later. You could have a decision short of going all the way through litigation with the cost and the invasiveness and the lack of privacy and all that. Arbitration is usually recommended for people who really aren't going to have a relationship somewhere down the line, or a very short-term relationship. Also, if they had any due process concerns at the mediation level where they really weren't heard and they really didn't have the formality of evidence and things like that. So arbitration can accomplish an expert that comes in and hears their case and can look at complex matters and make a pretty intelligent decision. Cost is shared. They make a final decision. You bring some finality, and we focus on facts. Rarely do we focus on the emotions. As I said earlier, the cons are it can kill the relationship. It has a chilling effect on people who say, "Well, arbitration, it didn't really work for me, or it didn't work for him, so I'm really not going to do it." And at the end, there's a possibility they could disavow the whole solution because they didn't come up with it themselves. So I can't attribute this to anyone, so this is the famous philosopher named Anonymous. He says, or he or she says, when you're at the edge of a cliff, sometimes progress is to step backwards. So the final one that I'll present is a case evaluation. This is gaining some traction here in California. It's kind of like an alternative where you feel like you can vent your position and list your strengths and weaknesses, and you get to kind of interface with the other side and your side, and very often it can lead to settlement. One of the positive things it does, and I think this is why the courts tend to look at settlement conferences and other kinds of interface between the lawyers and the parties, is that it can narrow the issues. And one of the things that you can sell for progress to your client is if we could refocus the issues and get them down to a manageable few, then we're not going to spend so much time in court. We're not going to spend so much time arguing and carrying on in that format. So, and this can come at any time during the process along that continuum or along the legal process to try to cut that 22 months down to a manageable measure. However, you cannot use this for things that don't involve money, because money is the easiest denominator to award. If you need something like an injunction or a restraining order, this doesn't work. And so this wasn't made for that. You can have it during the process, as I said. You can have it set up as a settlement conference. You can meet with a judge or a neutral person. And filtering, and judges love when you narrow the issues and you give the strengths and weaknesses of your case, because it gives them a lot of time to manage the time and the amount of resources they have to commit on their already belabored calendar. An alternative that we always offer that has also gained popularity because of the parties wishing to head off this litigation freight train is that they now always could, but now they could provide in their contracts of relationships and dealings with other people, whether they're vendors or suppliers or whatnot, they can put in an arbitration clause, which says that not only if we have a dispute, this is how we're going to settle it, by arbitration or mediation or whatever, and then they put in a choice of forum clause, which says this is where we're going to settle it, and then they put in a choice of law clause, which says this is the law that we're going to use. I remember years ago, I had a client that got in trouble with one of her major providers, major suppliers, but they were in Connecticut. And the only law that I knew in Connecticut was what I learned on the plane going from California to Connecticut to do this arbitration. And I said to her, why did you ever agree to go to Connecticut to do an arbitration unless you're going to find a Connecticut lawyer? And she says, well, I wasn't thinking that far ahead. And I said, yeah, well, unfortunately for me, I'm going to go there and try to argue California law, and some of it may work, some of it may not, but every state is different. And unfortunately, we're not as consistent in our applications as they want you to believe in law school, let alone in practice. So we say to our clients, and I say to my students, anyone who does business better put in an ADR clause as to how you're going to settle a dispute. Put in what law you're going to use to resolve it, and then finally put a forum location for which state. So it could be California federal law or California state law, and we're going to use arbitration or mediation or whatever we're going to use. But that tends to head off a lot of this uncertainty in this process. So maybe, just maybe, from the court's perspective, maybe we're going to get a menu-driven design your own ADR system. You know, we've already started to combo different things like med-arb, which is mediation and arbitration, where if one fails, we automatically flip over the page and go to the next one. We may tailor different processes to certain problems that if we need experts or people who need to come in with certain expertise. We could have maybe some of the issues heard by one expert and maybe other methods that could be heard by other things. Maybe we could identify some things that were useful for mediation and other things that might be useful in arbitration, and then try to preserve maybe part of the relationship. And then the other thing we can do is that's a better idea to combine and tailor to the situations such that you'll have an enforcement method to follow up later to see if it works. And I think that could be the future, is that we're going to get out of this mindset that's been formed since the Constitution was signed and get into a better alternative. Because it is a fact that this is a litigious society. I tell my students and my clients that when children are born, they learn three things. They learn daddy, mama, and I'll sue you. And it can happen that fast. And I have clients that call me all the time that have these great ideas. For me, not for them. It's going to be good for me to make money, not for them. I have a hairstylist in Laguna Niguel who's a wonderful person, but he's always criticizing me because every idea he comes up with, I poo-poo it, as he would say. And he decided the other day to call me, and he said, I got a great idea. And I'm going, oh, this is going to be great for me. I'm going to make a lot of money. And he says, I want to give neck massages to all my clients. I said, bad idea. I said, if your hands get in the danger zone, one slip and you're in court and someone's going to own your shop. And he goes, you're so disagreeable. So if I let him go, then he's going to be disagreeable. So I'd rather I be disagreeable. But this may be the future. And it may be a menu-driven or tailored to each specific type of dispute, rather than put an umbrella approach in for either negotiation, mediation, or arbitration. There have been various court decisions. I won't bore you with all of these, but there seems to be growing support for arbitration agreements. There seems to be support for these kinds of agreements being sustained in court, that they can be valid, and also they're looking at great scrutiny at other options other than the traditional means. There was a study done in 2009 by the Attorney's Office as to who used ADR, and I don't put this up because it has any special relevance other than because it validates some of the numbers that I showed earlier. The key data, I think, is in paragraph 3, where it says that when ADR was used, it settled about 65% of the cases, and it was helpful in 17% more because it narrowed the issue. So there's 82% of cases that could be valid with some form of ADR. And I think if you look at the last paragraph, this lends credence to the fact that maybe we ought to be more creative and let the parties come up with some other options other than what the court determines is logical for them. I equate the court telling people what to do, similar to the way we approach our students as teachers. In the old days when I went to school, they would teach from a book, and they'd give us traditional activities, and they would teach us basically what they wanted to teach by the curriculum or whatever the powers to be said, that's what you teach. Today's millennials don't want to hear that. They got just enough time to listen to about 30 seconds of you, and then you're technologically too long for them. These are people, these are children that are very complex. They don't want to go out. They stay home. They can date, go to school, buy food, whatever they want to do, and stay home and never see a social human being. And yet, they're constantly looking for reinforcement. You're doing great. You're doing great. And the students, we have to teach them differently, just like the court has to deal with people that come to them. We have to teach our students in a new way, which says that we expose them to the theory, we give them technological outlets to use, and in that manner, maybe they'll come to trust that we really led them in the right direction. That's really what it is. Because we can't teach them the way we were taught. Unfortunately, it's not a traditional model anymore. So the courts have to get with that as well and say, okay, we got to change. If ADR is working to resolve or to assist in 80% of the cases, and in the last paragraph it says that it was more effective when it was voluntary. 71% more effective versus the 50% when we told them they had to do it. And you know just from life, when you tell people to do stuff, their first reaction is, why? Because these millennials don't do what we did when we were kids. I remember my first job. Someone said, paint this wall. I said, where's the bucket? Where's the ladder? Where's the paintbrush? Today you ask a child to do that, and they're going to contract it out. They'll outsource the thing. Or they'll give you 100 reasons why they're not interested in minimum wage, or they're not interested in what you have to say. They got to figure out another way to get around that. So 71% voluntary, 50% mandatory, and they settled more frequently. So what's the lesson? Well, I can't close this with any better a source than Abraham Lincoln. I love Abraham Lincoln. I'll tell you why. I love him because I'm very much like him. When I was in law school, Lexis, Nexus, Schmexis, whatever. I wanted to have those books in my hand, smell those pages, turn those pages, run them all over the floor. And today I still do that. The dinosaurs, okay. But Abe Lincoln, he was always a figure that we talked about when I was a kid. And I remember my grandfather telling me this story, and that Abe Lincoln walked through the snow to go to school or wherever he went. And I tell people the story now that when I was younger, I was so poor. On one week, we bought the left shoes, and on the next week, we bought the right shoes. So I love Abraham Lincoln. And he said, we need to discourage litigation. He said, persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often the loser in fees, expenses, and a waste of time. Now, I understand that's anti-lawyer speak, but I'm going to say it anyway because he said it. He said, as a peacemaker, the lawyer has a superior opportunity of being a good man, or today a good woman, and there will be business enough for all of us. With those thoughts in mind, thank you for having me, and thank you for putting up with me, and I hope all of you will consider ADR as a viable alternative if you have to use it. Thank you.